Okay, you are welcome to this video. My name is Lucky O Iredose, PhD BL. I'm a legal practitioner and, of course, a healthcare administrator. So, in this very series, which is the part one of the series of lectures I'll be giving on medical law and forensic medicine, I'll be talking about the foundation of medical law. And these various topics I'll be discussing will be culled from my book titled Medical Law and Forensic Medicine in a Nutshell, From Clinic to Courtroom. So it is a full book on medical law and forensic medicine. Now, today I will be starting with the foundation of medical law. Foundation of medical law. Then I'll be using the Nigeria experience. I'll give an overview of historical and legal foundation of medical law as far as the Nigerian experience is concerned. And I'm equally sure that every jurisdiction have the way their medical law has evolved over the years. Now, in the beginning, let me start from the pre-colonial legal systems in which the Nigeria state, as it were, was not yet in existence. So Nigeria was made up of several different autonomous communities and kingdoms. Not until the advent of the amalgamation of 1914. So before this 1914, the various autonomous communities and kingdoms in Nigeria had what is referred to as indigenous legal systems. And these indigenous legal systems were responsible for governing the medical industry of the various communities. And of course, the medical industry or medical practice, as it were governed by customary and Islamic laws. These laws were used to regulate the conduct of um, medical or the healing practices. And of course, in the northern region of Nigeria, I will take a look at customary and Islamic laws there. In the northern region of what is today known as Nigeria, Islamic law was the dominant law that regulates the practice of medicine. And it was recognized as the customary law as at that time. See the case of Alhaji L.A. Onibudo and others versus Alhaji Akubu A.W. and others. Then in the northern part of Nigeria, the various traditions, values, and practices that were holding sway at that time were used to regulate the practice of medicine in that part of the country. And of course, in the case of Awoniyi against Omotosho, the customary law that were taking place in southern Nigeria were described as the mirror of accepted usage. Now, let us take a look at the nature of customary law. Customary law, as it were or are largely unwritten, were based on long-standing practices. Irrespective of that, they must be reasonable and, of course, consistent with the law of the land. Therefore, they must not be contrary to statutes or to common law or to the constitution of the country, as today Nigeria is an independent country. So the import of what we are trying to say is that though customary law regulated the practice of medicine in the pre-colonial era or even till the colonial era, so to speak, such customary law must not be repugnant to natural justice, equity, or good conscience, or must not be in conflict with any law that is in existence. For example, the Constitution of the Federal Republic of Nigeria. Where such is noticed, such customary law will be shut down or declared null and void and of no effect by a competent court of law. Now, how was medical law operated? How was traditional medical practice operated in the era that I just described? Now, you know that the traditional medical practice falls under non-orthodox healing method. Like I did say in my opening paragraph, this practice was guarded by cultural ethics. Although there were no formal medical law as we know it today. However, it was not tolerated for any medicine man to commit error in the course of treatment. If us, if such error were detected and it was found that it was intentionally committed, such was always considered to be a taboo. And such a traditional healer will be well dealt with according to the prevailing law of the lands. Now, let us take a look at introduction of modern medical law. You see, the introduction of modern medical law in what is today known as Nigeria after the amalgamation of 1940 was influenced by colonial ties with England. Remember, Nigeria was colonized by the English people. Therefore, English law became major legal source and today has become the foundation for modern medical regulation. Of course, we know that the English law, as it were, actually, have a part of it or were rooted in common law, though equity came later to gloss over the common law. Now, the common law were law developed by the English judges. These judges were itinerary. Though this is not a part of medical law per se, but I am giving a background for subsequent topics that I'll be treating under this medical law and forensic medicine. Now, based on the judicial decision of those itinerary judges in England, a lot of body of law was put together to become the existing law of the land that was taking place in England. Hence, it was therefore referred to as the common law of the realm. As the common law was referred to as the common law of the realm because every part of England as at then, where the itinerary judges passed judgments, they collected all of them together and formed them into a body of law. And this was what was applied to Nigeria through the doctrine or the process of reception. That is why we in Nigeria today we call the received English law in Nigeria. Now, let us take a look at common law and medical practice. Common law and medical practice. This common law, as it were, like I explained before, influenced so much cases of medical negligence in Nigeria and court has to rely on the precedents that were laid down by those by those judges that passed those judgments on negligence cases in the English legal system. And of course, if we say that there was a precedent as far as medical law was concerned, this includes law of torts. That is to say, the law that were actually applied to the treatment or handling of medical negligence cases were laws mainly that govern torts. And torts usually is made up of negligence and trespass. And all these continue to shape professional ethics in medical practice in Nigeria. Now, the Constitution of the Federal Republic of Nigeria was equally enacted with the process of time. And as it is, the Constitution is the supreme law of the land, which is referred to as the ground norm or the faucet or rigor of all laws. Reason be that the provisions of the Constitution binds all authorities and persons within the jurisdiction of Nigeria. And it overrides every other law that is inconsistent with the Constitution to the extent of the inconsistency of that law. So what we are saying is that if any law is in conflict with the Constitution of the Republic of Nigeria, such law will be declared null and void to the extent of its inconsistency. Now, as far as medical law is concerned, the Constitution of Nigeria lay a very solid foundation under the fundamental rights provisions of the Constitution, as found in Chapter 4, specifically Section 33, which provides for rights to life. Section 34, which talks about the dignity of human person. And of course, Section 35, which has to do with personal liberty of the human person. And many other sections that the Constitution of the Federal Republic of Nigeria provided for the regulation of medical practice in Nigeria. Therefore, the Constitution influences medical decisions and legality of so many things that we talk about as far as medical law is concerned in Nigeria. Now, in Section 17 of the Constitution of the Federal Republic of Nigeria, that's Chapter 2, it is provided that the state shall provide adequate healthcare facilities for all Nigerians. But eventually, this section of the Constitution is not justiciable, therefore cannot be enforced in a court of law. But I just want to explain here to say something to my learned friends, seniors, and SAN, that something could be done to see how this part of the Constitution can be enforced if there are other legislation that make it possible for this provision to be enforced. I think that is left for legal minds to do further research on how to go around this. Now, let us take a look at statutes in medical law. We have laws that are made by the legislative bodies. These are statutes specifically provided for the regulation of medical practice in Nigeria. For example, we have the Medical and Dental Practitioners Act. I'll get to that. Then there are key tools for legal development. And of course, there are also a way to regulate medical practice formally aside the provision of various statutes. Now, let me delve a little into historical development of statutes. In 1963, Medical and Dental Practitioners Act was enacted, and there was subsequent amendment in 1966, 1969, 1979. And of course, in 1988, there was also new act that was enacted to regulate the practice of medicine. And there have been a lot of enactments in different ways and manner and amendments to regulate the practice of medicine in Nigeria. So in subsequent lectures, I will be taking this one after another. So being that this is an introduction, let us just leave this the way it is for now. Now we have the Medical and Dental Council. The Medical and Dental Council is an establishment of the law, and they are responsible for the registration of qualified healthcare aspirants to become qualified practitioners. And they have to maintain professional standards and, of course, oversees training and certification of health or medical practitioners. So here it is necessary to state the legal requirement to practice medicine in Nigeria. This is for medical doctor, though there are a lot of other legislation, like I did mention before, that regulate the practice of other persons in the medical and health field in Nigeria. For example, we have the Medical Laboratory Science Council of Nigeria Act. We have, I think, the Pharmacy Council of Nigeria Act, and so many of them like that. But for the purpose of this introduction, I'm just laying emphasis on the the acts that regulate the practice of medical doctors. Now, legal requirement to practice in Nigeria stipulate that it is the act of registration that qualify a person to practice medicine in Nigeria, not the act of qualification. That is to say, qualification alone is not sufficient for anybody to hold himself or herself out to call himself or herself a medical doctor in Nigeria, unless such a person has been duly registered by the Medical and Dental Council of Nigeria. Therefore, an unregistered practice is a criminal offense in Nigeria. Anybody that is not registered by the council is not qualified, even if you have your MBBS or your first degree in dentistry, you are not qualified to hold yourself out as a medical doctor for the purpose of practicing medicine. If such a person is caught, the person will be made to face criminal charges. And if convicted, the person will be sentenced to prison. Now, there are challenges. There are actually challenges in the practice of medical practice. And I'm sure this is not limited to Nigeria, and other jurisdictions equally will be going through this process of challenges. Now, in Nigeria, we have the presence of orthodox and the non-orthodox practitioners. That is to say, there are herbal practitioners, the traditional healers, the faith-based organization. All these are involved in the practice of medicine, in addition to the medical doctors who are in in orthodox practice of medicine. Now, the issue is that the system or the environment, the healthcare system is agog with different kinds of persons claiming to practice medicine in Nigeria, both from the orthodox type and the non-orthodox type. And these pose a lot of challenges. As a result, there is rise of quackery, and of course, there is the presence of weak regulation of traditional practice. Though at the Federal Ministry of Health in Nigeria, there is a dedicated section that regulates the practice of tradomedical the tradomedical medicine, or so to speak. Now, in conclusion, medical law in Nigeria is rooted in customary law, in common law, in the constitution, and of course, in various statutes. Without stating the list, medical law and practice in Nigeria is strongly influenced by our contact with the colonial masters. Of course, there is always ongoing challenge in the regulation of medical practice. Thank you very much, and I would like to see you in my next video. If you need the book, which is Medical Law and Forensic Practice from Clinic to Courtroom, please, you can reach me on WhatsApp number +234 815 745 8711. Please let me just take you back to the book. Let me take you back to the book. You will see that this is the book, Medical Law and Forensic Medicine, a nutshell from clinic to courtroom. So you can order a copy of this book and you will see in detail everything or most of the things that you need to do about medical law and forensic medicine. Thank you and God bless you.